on how to treat the kid from doing bad behavior, such as he had weed in his system, and oh gosh, what else did he do? Stole video game.
Yes, sir.
We also learn about like status offenses. We also learn about like status offenses.
Status offenses?
Yep.
So the difference between status, what is the status offense?
Status offense is like an infraction only a juvenile can commit. So like someone like me can make that charge.
Hate crime.
Yeah. So yeah.
What else?
Nature of the offense.
What were the three things I told you to think about when it comes to assessing a juvenile's case? Oh, Nate.
Age of child, nature of the offense, and prior knowledge to history.
Yeah. Colin.
I was gonna say something about that.
Other than that, we didn't learn a whole lot. We basically got to know each other. I kind of introduced us to the system. I started talking about three other things I wanted you to think about. I wanted you to think about a child's environment. I only mentioned number one. Do you remember what the first one I mentioned was? Home environment. Then I went off into a tangent talking about home environments and stuff like that. I got sidetracked, so I apologize for that. There's two other environments. This ain't in the book, but this is something to consider when you're assessing a child's case because we've all lived it. There's only three places that a child can be at any time during this 24-hour period. The home environment, the school environment, and their peers, the social environment. If they're not in school and they're not at home, they're out with their peers. So a lot of times in my history of working with kids, the ones that we dealt with, delinquents, the ones that found themselves in the court system, were experiencing problems in one or all three areas: their home environment, their school environment, and with their peers. So when you're assessing a child and we're sitting there and I'm talking this legal mumbo jumbo to you and I'm telling you to start thinking about age, seriousness of the offense, how much the prior criminal history, well, you can't help the child unless you're looking at the child's full picture. And so when you start to do your assessment and you're actually interviewing a child and his parents, you want to be thinking in the background about those three environments, if there's anything you can learn about that child and anything that you need to report to the judge. The juvenile justice system is complex. It's not easy, and it's a lot of terminology, which we'll get through this course and you guys will learn some of it. Hopefully you take something away with you. But this is a short little video I like because it starts to get you familiar with some of the terminology. And it just talks about it being difficult. Remember, it is a process.
Juvenile delinquency court is
confusing,
intimidating,
overwhelming, emotional.
The juvenile justice system can be all of these things, but it doesn't have to be. Although different counties and different judges can have unique ways of running their courts, this short video will give you a basic idea of what to expect in juvenile delinquency court and the most common kinds of hearings. Delinquency court deals with youth under 18 who have been arrested or given a ticket by an officer for doing something that would be considered a crime if done by an adult. Many of the hearings that are held in delinquency court are similar to what we see on TV. However, juvenile court hearings have different names than those in adult criminal court and very different purposes too. While adult criminal court usually focuses on punishment, the aim of the delinquency court is to help the youth so that he or she does not commit any further crimes and has a successful future. Some youth waiting for their first appearance in court may be in a position similar to Christina's. When Christina got into trouble, an officer arrested her and took her to juvenile hall to wait for her first court hearing. This is called being detained. Most youth who are detained have the right to go to court within 2 days after being brought to juvenile hall, not counting weekends or holidays. In some cases where violent acts are involved, that deadline can be as long as 3 days after being detained. Some youth, like Robert, may not have been brought to juvenile hall, even though they have a delinquency case. Robert was sent a letter telling him about his first court date, time, and location. This is called a notice to appear. It is very important that Robert comes to court on the day and time written in the notice. If he doesn't, the judge may issue a warrant allowing an officer to arrest Robert and put him in the juvenile hall to wait for his next court hearing. Whenever a youth comes to court, it is important to be on time and dressed appropriately. Because most juvenile court hearings are confidential, cases have to be called into the courtroom one at a time. While this is done to protect the youth's privacy, sometimes it can mean that there will be a long wait before getting a turn in the courtroom. The first hearing in juvenile delinquency court is usually the detention hearing. The purposes of the detention hearing are for the judge to make sure the youth knows why he or she is in court and to decide whether the youth should have to be in juvenile hall until a decision on the case is reached. In making this decision, the judge will think about whether the youth is likely to return to court for his or her next hearing, whether the youth is safer in juvenile hall, and whether other people are safer if the youth stays in juvenile hall. Christina's detention hearing is typical for a youth kept in the hall. She was brought to the courthouse in time to have a brief meeting with her lawyer before going into the courtroom. Youths in delinquency court have the right to hire their own lawyers, but because Christina couldn't afford to do that, the court appointed her one. Court-appointed attorneys are all licensed lawyers whose job it is to represent the youth. In order to do that, sometimes the youth's lawyer can't share all of the information about the case with the youth's parents or guardians. While parents and guardians, as well as crime victims, can be represented by a lawyer if they want one, generally they have to hire and pay for their own. Christina's grandparents, who are her legal guardians, had to be in the waiting area until it was Christina's turn to see the judge. Even though they weren't able to visit with Christina while they waited at the courthouse, it is important that at least one of them is present every time Christina comes to court. Not only do they need to know what's happening, but they may also have responsibilities as a result of Christina's court case. Parents and legal guardians may be required to participate in classes or other programs that are designed to help them and their child. They may also have to pay some of the costs of their child's juvenile delinquency case, including paying for as much of the cost of their child's court-appointed attorney as they can afford. When Christina comes into the courtroom, she sits at the table with her lawyer and is given a document describing what officers say are the illegal things that Christina did. This document is called a petition. The petition lists the different laws it is claimed or alleged that Christina broke. The items on the list are called the allegations and are similar to what is called the charges in adult criminal court. In Christina's case, the petition alleges that Christina got into a fight with another girl at school. The district attorney's office wrote the petition, and a lawyer from that office is in the courtroom. Christina's lawyer tells the judge that Christina denies doing the things that the petition says she did. This is called entering a denial and is similar to pleading not guilty in adult criminal court. After the denial is entered, the judge needs to consider whether or not Christina must stay in juvenile hall while her case is waiting for an outcome. To help provide information about this question, a juvenile probation officer will be in the courtroom. Just because the probation department is involved with the case at this point does not mean that Christina is on probation. The juvenile probation department has the responsibility to learn about all the youths who have a delinquency court case. A probation officer will write reports and make recommendations throughout each stage of Christina's court case, but the judge cannot order Christina to be supervised on probation unless she is eventually found to have done something that was wrong. Also in the courtroom is a court reporter who is writing down everything that is said during Christina's hearing. It is important that people take turns talking without interrupting and answer out loud instead of just nodding their heads, so that the court reporter can write things down accurately. A courtroom clerk assists the judge with tasks such as keeping track of the court's decisions and schedule and summarizing what happened in court in a form called a minute order. The bailiff's job is to keep the courtroom safe. In many courthouses, the bailiff will also call the cases into the courtroom. Sometimes there may be an interpreter present in court to help people who don't speak English. Youth, their parents or legal guardians, and crime victims are entitled to have a court-appointed interpreter help translate what is said in court. There is no charge for this, and anyone who needs an interpreter should let someone from the court or the probation department know as soon as possible so that an interpreter can be brought in. Don't be surprised if you do speak English and still don't understand what people are saying. Too often, court hearings have a lot of technical legal terms being used. Don't be afraid to ask for an explanation of what is being said. After considering all the information she has, the judge decides to keep Christina in juvenile hall and schedules her next court date. The next time Christina comes to court will be for a pretrial hearing. Sometimes called a status conference, the purpose of this court date is to see if the case can be resolved without a trial. If it can't, then a judge needs to find out if the attorneys are ready for the trial. Pretrial hearings aren't held in all counties, and sometimes even counties that use pretrial hearings won't have one if the judge and the attorneys don't feel like one is needed. Since Christina disagrees with what is said in the petition and police report, her attorney lets the judge know that they will need to set a trial. The trial date is called the jurisdiction hearing because it's the hearing where the judge decides whether or not the youth committed a crime, which would then give the court control or jurisdiction over the youth. Like in an adult criminal case, the district attorney must prove beyond a reasonable doubt that Christina did the things alleged in the petition before the court can take jurisdiction. Both the DA and Christina's attorney can bring witnesses to court, question the witnesses that testified, and make arguments to the judge.
Objection, Your Honor.
After listening to the witnesses, the judge decides that the district attorney did not present enough evidence to prove their case. Therefore, the court does not take jurisdiction. Christina's court case is over with, Christina gets to go home, and she does not need to return to court. When Robert went to his detention hearing, his petition alleged that he broke into a neighbor's house and stole some alcohol and a small amount of money. Like Christina, Robert also entered a denial at his detention hearing. However, now that Robert and his attorney have had a chance to talk further and investigate his case, Robert has decided that he doesn't want to fight it at a trial. He decides to admit to doing the things listed in the petition. After entering his admission, Robert will come back to court to find out what the consequences will be. This court date is called the disposition hearing and is similar to what is called the sentencing hearing in adult criminal court. However, the purpose of a juvenile disposition hearing is for the court to decide what the youth needs in order to learn from his actions so that he doesn't continue to break the law. Before the disposition hearing, Robert will meet with a probation officer who will write a report for the hearing. The report will make recommendations about what Robert should do to work on the problems that caused him to get into trouble. The report will be available at least 2 days before the disposition hearing. At the disposition hearing, the judge considers suggestions listed in the probation report. Since Robert committed a crime that had a victim, that person can speak in court at the disposition hearing about the incident. Robert's attorney and the district attorney may also make suggestions to the judge about what they think the most appropriate outcome should be. There are many rehabilitation options available to the judge, including some that involve punishment. The judge may choose to allow Robert to live at home so long as Robert does certain things the court wants him to do, like attend school or go to counseling. If the judge decides that Robert needs to have more supervision while he gets help, the judge can send Robert to a treatment program, in a group home, or spend time in a detention facility such as juvenile hall or a probation ranch or camp. For some serious crimes, a judge can order a youth to go to a state-run correctional center that can hold the youth until he or she is 25. After considering what is in the probation report, as well as the information he heard at the disposition hearing, the judge decides to place Robert on probation supervision. The judge makes an order listing the rules and requirements that Robert has to follow while being supervised. These are the terms and conditions of probation. It is important that Robert understands what he has to do while on probation, because if he doesn't, and he later fails to do something that is required of him, Robert may get in trouble with the court and face more serious consequences. Since the victim lost money because of Robert's actions, the judge will require Robert to pay for any loss or damage that the actions caused. This is called restitution. Robert's parents may be required to help him pay off the restitution that is owed. Robert will get a copy of the court order from his disposition hearing, either in person or by mail. This document will list the terms and conditions of Robert's probation and should be kept in a safe place. In some cases, a youth may have to come back to court even after the disposition hearing. Usually, this is for some kind of review hearing. Review hearings are generally held so that the judge can see how a youth is doing on probation, is progressing and paying off any restitution, or because the youth was placed in a group or foster home and the judge needs to evaluate if that home continues to be the right place for the youth. Robert should keep his attorney's phone number even after he has stopped coming to court, because if Robert successfully completes probation, he can speak to his attorney or probation officer about the possibility of going back to court and having his case sealed, which means that it would be removed from his record. While juvenile delinquency court may be a scary and emotional process, knowing what to expect and where to get help should make it more manageable. Hopefully, a youth's involvement with the delinquency system will eventually be a step in the process of building a successful future.
That gives you a little bit of insight to kind of what the process looks like. The key word they said in there was jurisdiction. What is jurisdiction? Anyone? Yes, sir.
It's the court's, I think it's the court's ability to punish someone.
The lawful authority, the word's authority, the authority to hear that case. What county do we live in?
Allen.
Okay. What county is Cherubusco?
Whitley.
Part of it's in Allen, but Whitley County, okay? If a child commits a charge in Whitley County, that child has to go to court in Whitley County because they fall within the lawful authority to hear that particular case. Now, what they can do is say a child is from Allen County, goes on vacation and goes to Chicago and commits a crime. Then Chicago can then actually place that child on probation in order for supervision to occur here in Allen County. Okay, does that make sense? I'm getting into the real sticky details of it, but they have what's called interstate compact and intra-state compact. Good job, you know. Inter is within the state, county to county. Intra is state to state. So from Chicago to Illinois or Chicago to Fort Wayne, which one would that be?
Intra.
Intra-state compact. So you got them? We don't really get into that, but I want to show you how jurisdiction is very important. It matters where you committed the crime, and it's the lawful authority. An Allen County court cannot hear crimes that was committed in another county unless it was transferred in after it goes through the court process. Did all of you guys see the announcement that I posted in regards to the tour at ACJC? It didn't pop up?
Yeah, I did.
Huh? You did? You saw it? So it's in there? Okay. Well, you guys really should be checking your post or the announcements, because I put a lot of things in announcements. I used to send them out in emails, and I figured it's just easy because you'll always have it there in case you don't need an email. I need to know a confirmation from you guys. I still have contacts with ACJC, the juvenile facility, and for every class that I've ever instructed, we do a tour, and then right after the tour, we just go ahead and take our midterm, and then you guys go ahead and leave. Are you guys interested in this tour?
Yeah.
Everybody? You get to basically, this brings the book to life. I can stand up here and tell you about it, but you get to actually see from where the police cars drive in. I don't really go through there, but where the police cars drive into the sally port, the door goes down, they take them into the intake area or detention area. They get handcuffed to a bench. You get to see all of that. You get to see, it looks like a jail. There's two sides of it. There's the brick and mortar side, which is the detention side, and you guys get to experience the The fact that when those doors slam behind you, you're stuck and nobody's there to let you out until they push a button. And then you get to see the beautiful side of it, the courtroom side of it, what all the courtrooms look like, and then the intake area and how the parents come in. Now, two things. Number one is that child is either in custody and they bring them down from court, or that child's out of custody and they're just told to show up for court. But you'll get to see the whole process and ask questions. You'll get to see the rooms that the kids are in. You'll get to see the day room that they get to go to play in, and what activities are available to them. At the same time, we're going to meet next week for class, and then the following week I'm on vacation, and so you guys won't have class on the 17th. And what you're going to do in between after our class next week and those 2 weeks is you're going to write a paper. I'll give you more information on the paper next week, but that paper is not too difficult. It's basically your knowledge. You're just conveying to me that you went on the ACJC link. I want you to be prepared before we do the tour. So I want you to go into the ACJC link. I want you to go through all the areas like detention, probation, intake, go through all the areas and tell me something about it. Tell me what you learned about it, and be prepared so that when you do this tour, you guys can do that. I do not plan to keep you guys here the whole night. I'm not up to 100%. I don't want to stand up here and talk the whole time and lose my voice. But I also want to make sure you guys are prepared for chapter 1. How many of you brought your books? All right, if you have them out, turn them over. If you don't, sit next to someone so you can. Write this down. Limited jurisdiction. Limited to what? That jurisdiction to have the lawful authority. Juvenile proceedings are considered to be informal versus adults, which are formal proceedings. Here's a big one. The juvenile court focuses on the offender and not the crime. So it may be that that child committed a C felony, but that child's still only 14 or 15 years old. So they focus on the offender and not the crime. They consider the crime, but you were right in that the focus is on the rehabilitative of the child. So it focuses on the offender and not the crime. Indeterminate sentencing. You guys know what indeterminate sentencing is? You guys from corrections should. Indeterminate means there's no set date. If you had a choice between determinate and indeterminate, you'd probably want determinate. Tell me I'm getting 5 years so I know what to count on, because indeterminate means I could get 5 to 10. I don't know what I'm getting. And the big one, as you guys should always remember for juveniles, confidentiality. Confidentiality, it goes to adult courts as well. We in the probation department, when I hire interns, I tell them, look, when you come up here, we don't share records with anybody. You know, you may see somebody you know, or you may know somebody that knows somebody, but we don't share records with anybody. You have access to files, you get to see things, but we don't share that. But the newspaper can share it. They share names, they tell everything on the adults. The juvenile court, although you will see some juvenile names, but back again, they're going to be doing for those murders or shootings or things like that. Lindsay, what is parens patriae?
That's so easy.
The concept that originally applied to juvenile matters means that the king is in charge of making decisions about the responsibility for all matters on the juvenile.
Good job. This is going to be a reoccurring theme throughout the textbook. Perez Patre, father of the country. All right, you're in juvenile court. Who's the father?
The
Judge. This philosophy means, now this is funny, I'll go back to my childhood, now that I've studied this and kind of know this. The philosophy is because this is with juveniles and it's not with adults. With adults, if you guys go out and commit a crime, can you bond out? You can bond out. It depends, but if it's a bondable offense. But if you're a juvenile, they can keep you and there's nothing a parent can do. Now, most parents would probably be of the belief that, well, fine, he deserved it, he can stay there. Matter of fact, some of you might have had a dad that said, don't call me if you get locked up. You know, you're gonna spend the night there. My mom would have been the opposite. My mom would have parked her bottom right outside the ACJC and would have sat out on the front lawn until they did release her. That's just the way she was and everything. But father of the country, so the philosophy is this, that falls into the rehabilitative nature of the juvenile court. The judge knows best, and they're going to do what's in the best interest of your child. Now, the other side of that is going to be the Get Tough movement. So, Laney, what is the Get Tough movement?
It emphasizes swifter, harsher, and more certain justice and punishment than the previous dominant rehabilitative philosophy.
You were ready for that.
I was.
The textbook with that mind of thought refers to these kids as what?
Many adults.
Mini adults. They're mini-me's, they're mini adults, and therefore we're going to do swifter, harsher punishments. And, you know, I don't think it's it takes rocket science to figure out which side I fall on, you know. When they started following JDI, before they started following JDI here in Allen County, ACJC, the numbers could have been like 125 kids locked up over there. The police were making the arrest, they were making the referrals, they were going into ACJC. However, they changed this philosophy, and it's based off of statutes, it's based off the law, so now the judges have to follow the law, which means that the police might take you to ACJC, but they're not going to keep you. They're going to do their best to get you out. So now these kids are going out. I'm not saying that's the result, but what I'm saying is we're seeing a lot of kids that know that they're not going to be locked up at ACJC, and therefore most people are logical in their reasoning. If you're not going to lock me up, what's my punishment or what's the deterrent? The criminal justice system says, what's the deterrent? So getting you to think about it, because I don't want you to have my opinions. I want you to form your own, but I want you to know both sides. Throughout my career as an instructor, that's always the case. Get you to arm you with information so that you can weigh out both sides. Because if you end up in court, you're going to argue your case, but it might not be winnable if you don't know what they're going to present. So it's always the public defender versus the prosecutor, and always weighing it out, because our criminal justice system is an adversarial system. Adversarial meaning there's two sides to whatever happened. Caden, what is the difference between delinquent offense and status offense?
A delinquent offense is something that an adult can also get punished for, whereas a status offense is something that only minors can get punished for. So like runaway, underage drinking, truancy.
Good job. Greg, why is runaway behavior complex? Any guesses? Look at page 9, or, yeah, page 9. Actually, on page 10. Page 10. Neglect, parental drug use, abuse. See, when a child leaves the home, back to my 3 environments, and you're trying to figure out, you're assessing the case, and you're trying to figure out why the child left. Now, it could be real simple. It could be just simply, dad doesn't approve of the boyfriend and she just wants to be with the boyfriend. Or it could be, they don't approve of the girl and the boy just wants to be with the girl. That's a simple one. That's just incorrigibility and the child wanting to do what they want to do. But if it's something else on why that child's leaving the home, then you got to figure that out, you know. And why does that? Because a child's got to live somewhere, and we don't get to choose our parents. So if you're in that home and you're leaving that home, you're trying to figure out what's going on in that home. So you're possibly looking for marks on the child. You're possibly looking for asking questions of the parents of what are your rules? Does your child follow your rules? What is your punishment for breaking those rules? Do you enforce the rules? Sometimes we get into situations where parents just don't enforce rules. So we have to discuss that with parents and share that with the judge that there really aren't any rules and the parents don't follow the rules. There's not a lot of structure. That's the way we word that. There's not a lot of structure within that home. But you're trying to ascertain that. You're trying to figure out what did that child leave the comfort of warmth, housing, a bed, a room, whatever. Trying to get that. So runaway behavior is difficult. It isn't like you stole a candy bar or you stole a CD. That's pretty simple. You wanted the candy bar or you wanted the CD. Stealing, you know. In my line of work, I found out, and I hold this to the gospel till I leave the earth, there's 2 kinds of behavior that you'll never fix, ever. A thief and a liar. And if I catch you doing either one, I'll call you that. Most people won't, but a thief is always a thief, a liar is always a liar. You can't change that behavior. I got a brother like that. He'll look me in the face and lie to me until I catch him cold turkey. And guess what a person that you catch cold turkey will do?
Still lie.
Well, in the future they will, but as soon as you catch them, and you got to have proof. If you don't have proof, they'll still lie. You're exactly right. But if you catch them and got the proof, video or whatever, they hang their head down and they got another side. Because you caught them and they know you caught them. But those 2 behaviors, the rest of them, you know, with kids, when they get that way, the rest of them you can work with. But a thief and a liar will always be a thief and a liar. Now that sounds unhopeful. That sounds like, well, imagine you're in a relationship with somebody and you catch that person lying to you. How long does that relationship last, and are you gonna believe that person the next time something comes up?
Never.
There's gonna be doubt, isn't there?
Mm-hmm.
Okay, that's, you know, can that person stop? Yeah, but what do we, in the criminal justice field, the definition of, or I should say not the definition, the clue to future behavior is what?
Still lying.
Past behavior.
Yeah.
So if you look at past behavior and you have past behavior of lying, then I've got to guess. One of my biggest things is when I'm interviewing clients nowadays and they are listening to, I don't interview them anymore, but I get to walk down the halls and listen to the officers interview them. And they say, all right, now I'm going to be truthful with you. Stop. If you're going to be truthful now, will you tell me when you're not being truthful with me? Because I don't know which one and when to turn it off and turn it on, you know. But that's one of the kind of the people, all people do it. Yeah, all right, I'm going to tell you the truth now. I'm going to be truthful with you. So. Mari, why is truancy called a gateway activity?
it can lead to like gang behavior or substance abuse.
Yep. They did a study and they found out of those that are truant from school, of the males that were truant from school, 2/3 that they come into the court system, 2/3 of them tested positive for drugs. So if you're not in school, old people like me always say, idle time's the devil time. So if you're not where you're supposed to be, you might be doing something that you shouldn't be doing. That's why parents, the court system, everybody's always interested in what activities your kids are doing. Are they involved in any type of structured activity that is beneficial to them? Are you in band? Are you in sports? Are you reading? Or, what are you doing with your time besides hanging around with those that might get you in trouble? I've had people, it can happen, wrong time, wrong place, but for the most part, with crime, you probably kind of knew going in that somebody was going to do something. Give you an example. Somebody shows up, says, Aiden, you're a kid, you're 15, you don't have a driver's license. Aiden, get in the car, let's go. And you go to get in the car, and there's a screwdriver sticking in the ignition there. What's that tell you?
The car's stolen, he hijacked it.
All right. Are you going?
No, I'm not.
That's a good answer. Are you going?
I'm going.
My point is, kids do risky behavior. They don't think about consequences. They go ahead and go. But the clue was there, right? The clue was there that basically it was a stolen vehicle and you should not have gotten into the car. Lucas, what is stigmatization?
Social process whereby offenders are perceived as having undesirable characteristics as the result of incarceration or court appearances.
Yep, you just read it right off of page 12. Good job. Colin, what is the JJBPA Act of 1974?
Legislation recommending various alternatives to incarceration, including deinstitutionalization of status offenders, removal from secure confinement, prevention strategies, and rehabilitative treatments.
Good job. Nate, what is deinstitutionalization?
Eliminate status offenses from the board.
Removing status offenders from secure detention. Making sure we don't put status offenders in secure detention. At ACJC, we're not allowed to lock up kids at status offense. The police can bring a status offender, a runaway, or a truant to ACJC. They basically go ahead and do a P drop and drug test them and process them, and then they transport them out to a shelter care facility, which is Youth Services Center on Lima Road, but they cannot keep a status offender at ACJC. This is not one for a question that I wanted, but I want you all to look at pages 15 and 16, and just for your notes, look at the distinctions between juvenile and criminal court. They've got 7 of them listed. I'm going to leave that up to you guys to go ahead and pay attention to that.
What about these?
Alan, is taken into custody the same thing as arrest?
Olin.
Pardon?
Olin. Yes, sir.
Is it?
No.
Look at page 17.
17.
Yep. Under being taken into custody, what does it say? First sentence.
Being taken into custody is another term for arrest. Yes.
You want to change your answer?
Yes, sir.
All right. But look off to the side in the box. Taken into custody, a decision made by a police officer that a youth should be held temporarily. A officer can take, and this has been a question among the officials, an officer can take a child because they can't just release a child to no one they can take a child into custody and maybe they're trying to ascertain more information. But as soon as they apprehend a child, it's similar to an arrest. But that officer has discretion and at some point may decide not to charge that child. So therefore it's not an arrest. But if they have taken them and they take them down to the police station or they take them somewhere to get more information, they take them into custody, it's considered an arrest. However, the arrest may not follow. Jackson, what is preventative detention?
Authority to detain suspects before trial.
This is the big one with juveniles. They can lock you up before you've even been convicted of it or sentenced or adjudicated is the word. So basically they can lock you up before you've even been adjudicated with no bond. That's preventative detention. Yes, sir, Colin.
But isn't there like a 2-day limit to that or something?
A lot of times with the prosecutor's office, there's a 3-day limit as far, 2-day limit as far as if you're in custody before it has to be heard by the court. Yes.
Okay.
Okay. But there's also a 3-day limit if they need to decide whether the prosecutor wants to waive you into adult court. And you're following through with this with your class. You guys are following through with, it's all bound by rules and regulations and statutes that have to be followed. And if they're not followed, of course, attorneys can debate that and have the case tossed out. But that preventative detention is a big one because that's back to my point. A judge can do what they want. So if a judge decides that they want to detain you, they can detain you.
Okay.
Whereas in the adult system, if that's a bondable offense, that's a bondable offense. You have the money, you can get out. Now, in order to follow the process, and it might help you because some of you may be more visual than others, look at the chart on page 19. When we start talking about that juvenile justice, the adult system, the adult criminal justice system, it kind of mirrors the juvenile justice system in that the players are the same. We got probation officers, we got judges, we got attorneys. The terminology is different. This is probably something you're going to see on a test, so I would like you to run this, take it with you for when you move on after this course, and at least you have an idea. Here's the adult system. Here's the crime. You commit the crime, you go through the court system, and they do what? Convict you, right? You're convicted. All right, once you're convicted, then you have another court date and you're sentenced. This is where you found out you're guilty. This is where you find out what your punishment is. Now, we do the same thing, and it shows you in that chart, we do the same thing except we don't convict our children and we don't sentence our children. The process is very similar. Over here, the terminology just turns to adjudication. And over here, it turns to disposition, which is what they used in our video that we showed you earlier. So when we're talking about kids, the formal process is adjudication and then disposition hearing. That's when the kid finds out that they were basically guilty of the charge. And the disposition is when they find out what happened. Now, this takes a petition. The petition is the formal document that reads what the child did and where they did it. John Smith in the county of Allen, state of Indiana, did commit the offense of burglary, a Class B felony, by entering the home of 336 Smith Street. That's what the petition is going to read. So that petition is then read in court. That child admits or denies, or his attorney admits or denies. And then, depending on what happens, if they deny, it's going to go to, instead of a trial, it's going to go to a fact-finding hearing. And same thing, a trial, except they don't have trials by jury. And then from there, they're either found guilty and they go to the disposition hearing, or the prosecutor doesn't prove their case and it gets dismissed. So write that down, kind of have an idea of this process of what's going on with it. Aiden, what is a petition?
A document whereby a court official or can bring charges against a juvenile and ask the juvenile courts to hear the case.
Yep. That's all on page 20. Colin, what is intake?
It's a screening procedure usually conducted by a juvenile probation officer, and during which several recommendations can be made.
Yep. Colin, what is adjudication?
Action on the petition filed with the juvenile courts.
What does it say before action? A judgment.
Judgment.
It's a judgment. That's normally what it's a judgment on the petition. It's a judgment or action on the petition. The only other thing is you can just write this down. What is the disposition, which I just covered? What are nominal sanctions? These are verbal warnings or reprimands. What is restorative justice on page 26? And what is the difference between non-secure confinement and secure confinement? All right. Your assignment is pretty simple. Write your name and date on here. It's worth 50 points. It gives you 5 juveniles and 5 scenarios. I want you to associate a name with each scenario, or basically each disposition. So you're assessing each of these cases and you're picking one of those, and then on the back, read the instructions. 5 names on here, which one you associate with. On the back, then give me the overwhelming need, or explain your rationale for your decision for that child. What did you see? Why you recommended what you recommended. So once you've completed this, you guys are free to go. And I will see you next week. Would you pass these out for me, please? Thank you.
You have choice of programs.
Everybody have a good week.
Yes, we did.
So we read through the articles and then choose the name at the bottom and then choose one to write about on the back.
Put the name down by the one you think that's the most appropriate disposition.
Yes, sir.
And then on the back, give me the rationale. Why did you pick that one?
Okay. For each one?
For each one.
Okay.
Okay, just make sure you write the name so I know who that associates with. You guys don't know, but you're like many probation officers, you're learning how to assess cases and what's factual and important. Yes, sir.
What is diversion?
Pardon?
What is diversion?
Diversion?
Yeah.
Diversion is something other than going formal. So when we talked about a petition being filed, diversion would be anything less than filing a petition.
So like community service.
That's a good example. That's one of them.
Like probation?
Say Aaron's house, the brief counseling, any kind of counseling would be a diversion program. Now, a lot of times I say to students, would they just say, I recommend diversion? Well, Aiden, you can't recommend it if you don't have a program available. So you have to be specific about what program you're recommending for diversion. You guys all remember to bring your textbooks, so I'll be highlighting things in there for you for the exam. Thanks, everybody.
You as well. Take care.